Well, good evening, everyone, and welcome back to AJ103 Criminal Evidence. And tonight's lecture is going to be on Chapter 4, where we're going to briefly cover the USA Patriot Act, foreign intelligence, and other types of electronic surveillance covered by federal law. Now, this is a very difficult chapter to follow because the definitions and a lot of the subjects that we're going to talk about, they're very lengthy, and there's a lot of different pieces that have to come together in order for some of these things to take place and be applicable. So with that being said, don't panic. I'm going to cover the highlights in this particular chapter, and I'm not going to spend a lot of time digging down deeper into a lot of the subject matter because it's so technical and we just don't have enough time today. So with that being said, let's go ahead and just jump into our chapter and look at our featured case. So Richard Rublowitz, in cooperation with other family members and a doctor, began to illegally sell oxycodone. And the scale of the sales was pretty impressive. Between 2008 and 2012, he was able to gamble away more than about $900,000 while having no record of legal employment. Now, Richard brought his wife and other family members into the scheme. And during the investigation, DEA agents wiretapped his phone and his hotel room. In taped conversations, Richard implicated his wife, mother, 3 sons, and various in-laws. So read that case. It's a little bit longer. It's about 3 pages. And look at and think about how the investigators dealt with the different types of electronic surveillance that was used. And then you should be able to apply it to the actual case study and perhaps some questions that come up as we move through the chapter. So our learning objectives tonight are going to be to explain when a reasonable expectation of privacy exists, and understand how the Fourth Amendment interacts with wiretapping, explain how the Patriot Act impacts law enforcement, explain how the Wiretap Act of 1968 was modified, and then list the procedures and use of national security letters. Now again, I'm only going to touch on some of these aspects because, again, there are so many technical pieces as it relates to the discussion this evening. So I think, again, it's just, I'm going to keep it brief. So law enforcement's interest in conducting wiretaps and other forms of electronic surveillance has increased with the rapid growth of new forms of electronic communications. Now, since September 11th, 2001, fear of terrorist attacks has made ongoing seizures of international communication necessary. And we're going to talk about, this chapter is going to discuss something called the misplaced reliance doctrine, which applies specifically to eavesdropping. And then next, we're going to kind of look at the history of electronic surveillance search warrants or electronic surveillance warrants and their recent expansion. And a number of major federal laws, we're going to talk about some of those, including the Wiretap Act of 1968. We're also going to touch on the USA Patriot Act and how that comes into play as it relates to electronic surveillance and eavesdropping. So, eavesdropping has probably been done since people began keeping secrets from each other. Now, electronic surveillance, however, only emerged after the technology developed, and both involved the seizure of private conversations. Now, the key distinction noted in Supreme Court cases is that a person speaking knows if another person is present, but is unlikely to know whether electronic equipment is being used. Now, violation of trust by one party to a conversation is all that it takes to make what is said admissible in court. So, in situations in which the suspect knew someone was listening, the Supreme Court has placed the burden on the suspect to make sure that he or she can trust everyone who can hear what is said. So if you're sitting at the table having lunch and you're talking about secretive things, and you're in a restaurant and people can hear you, you can see how this applies, where the burden is on you or the suspect to make sure that you can trust those around you, or trust everyone who can hear what you're going to say. And this is called the misplaced reliance doctrine. Now, the person who overhears the conversation may carry tape recorders or transmitters or other high-tech equipment without prior authorization from a judge. Now that same rule applies if one party to a conversation allows law enforcement to hide recording or transmitting equipment on the other's premises. Now, in the feature case, our case study, DEA agents rented the hotel room adjacent to Mr. Rublowitz and overheard a conversation without using any type of listening devices. And the conversation is admissible, again, under the misplaced reliance doctrine. Now, again, we're super technical in this thing. So, the misplaced reliance doctrine, if you are aware someone is listening, the burden is on you to make sure that they are trustworthy. And there is no need for a warrant if one party consents to a tap or if they are the police. And this rule covers both persons and devices. Now, conversations to be protected, they need what we call an expectation of privacy. So stay with me. Now, the facts from two cases are going to help explain this doctrine that we're talking about. Now, in Hoffa versus United States, this is one of the leading cases. When Jimmy Hoffa, the president of the Teamsters Union, was on trial in what is called the Test Fleet case, the U.S. Justice Department had another union official named Parton released from prison so he could join Hoffa's entourage and report on Hoffa's out-of-court activities. Now, no electronic monitoring equipment was used, and Parton frequented Hoffa's hotel suite and overheard conversation about plans to tamper with the jury. And the test fleet case ended with a hung jury, and I think you guys should know what that means by now. That means that the jury couldn't all agree. So there wasn't a guilty or a non-guilty verdict. It was kind of in the, somebody held out, so they couldn't agree. And evidence supplied by Parton was used in a subsequent case in which Hoffa was convicted for attempting to bribe jurors in the test fleet case. Now, the Supreme Court found this was a case of misplaced reliance. Hoffa knew Parton was present, and because of that, he took the risk that he might report the jury tampering to the authorities. The fact that the Justice Department had planted Parton had no legal significance. So basically, what we're saying here is that you can have somebody go in somewhere as an undercover or an informant or something and listen. And even go in with some type of recording device. And you're not going to fall under this eavesdropping type issue, if that makes any sense. So the other case, federal narcotics agents used concealed radio transmitters in United States versus White, another leading case. And here they recorded conversations that the defendant had with agents in public places like restaurants, the defendant's home, and the informant's car. And the informant also allowed an agent to hide in a kitchen closet and transmit conversations between the informant and the defendant. And all of these recorded conversations were found admissible under, again, the misplaced reliance doctrine. Defendant White should have been more careful in deciding whom he could trust. And this even applied to the agent in the closet. White should have not relied on his friend who allowed the agent to hide there. So what is the misplaced reliance doctrine, and how do you define it? Well, defined, it says, no warrant is required to obtain conversations that can be overheard by the police or their agents based on the suspect's misplaced reliance. And each person bears the burden of restricting his or her conversations to people who will not reveal them to authorities. So that's kind of like the informant thing I was saying. So again, Hoffa versus United States. The government charged Hoffa, an important union official, with violation of the Taft-Hartley Act. And the critical issue was whether the government could place an informant into deliberations of the defendant, even when communications with defense's lawyers was taking place. And the court ruled that there was, in fact, no violation of the 4th, 5th, or even the 6th Amendment because the conversations were voluntary. So take a look at that case. It's pretty cool. And on page 417, there are examples of situation covered by the misplaced reliance doctrine and also examples of those not covered by the misplaced reliance doctrine. And those are the examples that I like you to look at. So in the Hoffa case, the police were allowed to use an informant, but what are the limits? Think about this case. And if a suspect claims his Miranda rights, can the police use informants to eavesdrop on the defendant? And should the police be allowed to use defense attorneys as informants? All really interesting questions. But again, we're not going to dig too deep just because of the technical nature of all this. So let me finish up a little bit with the misplaced reliance doctrine, and we'll move on to this electronic surveillance. So a spat of recent cases raising an interesting issue. The misplaced reliance doctrine gives the police the right to record conversations that the speaker exposes to someone who does not keep them private. Now, the same reasoning applies to recording actions the police do in public. There is no right to privacy for these public actions. Additionally, First Amendment issues are involved here. In one case, a man was arrested for using his cell phone's digital video camera to film police officers apparently using excessive force to make an arrest on the Boston Common. And he was charged with violation of the state's wiretap statute. Now, a federal appellate court ruled that gathering information about government officials in a form that can be readily disseminated to others serves a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs. And the court saw no difference between the rights of reporters to take video and those of the average citizen. The fact that many people now have cell phones with cameras refuted, if you will, the officer's assertion of a reasonable expectation of privacy. While reasonable restriction as to time, place, or manner of recording can be imposed, making recordings of officers acting in the line of duty in a public place cannot be curtailed. So basically, what they're saying here is that people can record you, specifically in public. So just kind of keep that in mind, and it happens quite often as well. So now let's move on to electronic surveillance. And we'll talk a little bit about the Wiretap Act of 1968. Electronic surveillance has particularly troubled the Supreme Court because it has a great potential for abuse. In both wiretap and electronic monitoring cases, the victim may be totally unaware that the government is listening. The key decisions on this topic were made in the late 60s and early 70s, and since that time, new laws have been needed because technology has rapidly advanced, creating opportunities for electronic eavesdropping that are much greater than those that previously existed. Now, law enforcement agencies currently utilize a variety of forms of electronic surveillance. In 2011, 2,732 warrants were issued by federal and state judges to seize wire, oral, and electronic communications. And wiretaps accounted for 96% of the warrants. And of those, 98% were for cell phones and other portable devices. 85% of the warrants were for cases involving drug offenses. California, New York, and New Jersey accounted for 62% of the warrants that were granted. Now, the U.S. Justice Department reported that in 2011, its agencies, the FBI, DEA, U.S. Marshal Service, the Bureau of Alcohol, Tobacco, and Firearms and Explosives, ATF, they obtained 19,068 orders for what we call PIN registers, and we'll talk about those, on telephone lines that affected 43,576 people. There were 18,548 orders for trap and trace devices that affected 46,565 people, and 837 orders for PIN registers were used on email and networks that affected 824 people. So think about this as you look at the issue of electronic surveillance. So originally, kind of in review, cases focused on trespass issues, if you will. Did the police have to trespass in order to, place a tap? And wiretaps on public phones, they didn't require a warrant. And we're going to look at a couple cases in a minute that talk about this. And gradually these standards changed, and we'll see why. And the key became an expectation of privacy, not the location of the conversation. And then eventually statutes were passed to regulate the procedure. So the top part, the first thing I talked about here, that cases, they focused on trespass, like where you were putting the device. And did the police have to trespass in order to put the device there? But now the statutes really talk about the expectation of privacy was the key, not necessarily the issue of how you put the thing there. So let's keep going. Reasonable expectation of privacy, the current standard for the Fourth Amendment protections, originally came from a wiretap case. Now, prior to that time, again, electronic surveillance focused on trespassing and anything that the police could accomplish without physically trespassing on the suspect's property was okay. It was permitted. And sometimes this went to the extreme of measuring how far the law enforcement had gone into the wall, let's say, between, putting or planting a microphone, let's say, in a wall to determine a trespass. And in one case in particular, Katz versus United States, agents had probable cause to believe that the suspect was using a telephone booth as part of an interstate gambling operation. And because of that, they planted a listening device. It was placed on the outside of the public telephone booth. Now, some of you may not even remember what a telephone booth looks like, but it's the little rectangle thing that you walk into, and it's like glass on the four sides. And this is in the olden days, I know. And you close the door. And the reason that you close the door would be for what? Well, that would be for privacy. So let me finish with the case facts, and you can kind of see how they're applicable. So they placed that device on the outside of the telephone booth. There was no trespass. Even so, the Supreme Court held that the government violated the Fourth Amendment. Katz had a reasonable expectation of privacy because he entered the telephone booth, closed the door, and kept his voice down. So kind of an interesting case, and here's the Katz case up on the screen that you can look at. So again, he used the payphone to operate this gambling thing, and the police recorded the phone conversations without a warrant. Because and they ended up overturning this case. And the reason is because early on, remember we talked about it was more about location. But now it's more about the right to privacy, and hopefully that's kind of sinking in now. So the issue of electronic surveillance warrants was reviewed by the Supreme Court in another case, Berger versus New York. And here, the court held that statutes authorizing this specialized search warrant must provide very precise requirements, including a description of the offense and the types of conversation the officers are trying to seize. And the warrant must also be limited to a short period of time. And although the court really didn't say how long or what the maximum length was, it was found that 2 months was actually too long. So the Katz case talks more about the exclusion because of the right to privacy, and the Berger case now focuses more on issuing of electronic surveillance warrants, the fact that they have to be specialized and contain very detailed information. So how about if we apply the law to emails, and then we'll kind of move on. When a person uses email to communicate to others, don't they also have a reasonable expectation of privacy? And shouldn't such communications be protected? And what limits would be necessary? And what about like your Twitter posts, or I know they don't use blogs anymore, but the textbook talks about blogs. So what about those? On page 419, there are some examples of, 420. There are examples of electronic surveillance that is conducted legally and electronic surveillance that is not conducted legally. So hopefully you can kind of look at that and get a little bit more information. So let me continue on with a couple of other things that I think I need to bring forward before we move into the Wiretap Act of 1968. So not all electronic devices, however, that transmit information are covered by the same legal rationale. And there's a couple of terms that you've probably heard me go over already. Now, PIN registers record the numbers dialed for outgoing calls. And trap and trace devices, those record the phone numbers on the incoming calls, kind of like caller ID. That's the best way I can explain it. And neither of those is covered by the Fourth Amendment or the Wiretap Act. And the reason is because these devices do not seize or record conversations. The Supreme Court here found no expectation of privacy in the telephone numbers because the telephone company has access to them. Now, Congress has passed laws regulating their use during criminal investigations, etc. And this legislation mandates that a court order be obtained before you can install a PIN register and a trap and trace, but it doesn't fall under the Wiretap Act, if that makes any sense, and I think I explained that enough to where it kind of does. So the Fourth Amendment does not apply to transponders, also called bumper beepers, if you will, as long as they do not enter a residence. Now, this has changed a little bit, so bear with me as we kind of go through this. A transponder emits a signal that makes it possible to track that transponder without maintaining visual surveillance. So it's like it's a tracker, if you will. And the Supreme Court held that the electronic device merely facilitates the surveillance process and is not a search. It did draw the line, however, when the container with the transmitter in it entered a person's house. Now, a 2012 Supreme Court case kind of cast doubt on the earlier ruling on transponders. So listen to what I'm saying. The case involved the installation of a GPS tracking device on the undercarriage of a vehicle while it was in a public parking lot. And the vehicle's movements were then tracked for 28 days. And information was automatically uploaded by cellular phone to a government computer. Well, the Supreme Court held that the installation of a GPS device on a vehicle and its use to monitor the vehicle's movements is a search because the government physically occupied private property for the purpose of obtaining information. And as a result of this ruling, a search warrant is required in order to install a GPS device, even when the installation is done in a public parking lot. Now, the U.S. Supreme Court has not really considered the Fourth Amendment ramifications of utilizing GPS features of a cell phone to track a suspected criminal's movements. And the opinion in a case, United States versus Skinner, focused on the fact that the Supreme Court's opinion in Jones considered physical trespass kind of a pivotal issue. And obtaining GPS data from the cell phone company did not involve trespassing. Therefore, the Sixth Circuit concluded that a warrant was not needed. And this court also found no reasonable expectation of privacy because the person voluntarily purchased a phone with GPS capabilities. Now, you're going to see some changes if we haven't already gone over some of those because of the advent and the constant change in technology. Now, it also noted, and then I'll be done here, that Skinner's movements could have been observed by anyone present. Therefore, using modern technology like GPS to monitor him did not violate his privacy. So hopefully that sheds a little bit of light on that particular case. So there are also multiple ways that information from a cell phone can be helpful to investigators. Now, if the phone's GPS feature is activated, signals are produced whenever the phone is turned on. So real-time tracking monitors the signals as they're produced. And a log may be recorded in the phone or stored by the cell phone provider. And cell site location information identifies the cell phone towers used by the phone. Now, while that information cannot pinpoint the exact location, actually it can get pretty close, of the phone, newer technology referred to as precise, persistent tracking is making it possible to more closely identify the location of a cell phone. And actually, in today's technology, again, you can get very, very close. And now, even in the 911 systems that are built in dispatch centers or communication centers in law enforcement buildings, if you will, and police stations, we can track sometimes where 911 calls on a cell phone are actually coming from. So again, you can get very, very close. Now, arguably, information stored by the service provider is the property of the company and not covered by the caller's expectation of privacy. Federal statutes, however, make it necessary to obtain a court order to obtain customer tracking data from those service providers. So hopefully you've kind of gleaned a little bit of knowledge that maybe you didn't know before on cell phones and GPS. Well, now let's talk about the Electronic Surveillance and Wiretap Act of 1968, the most exciting thing that's ever come about. No, I'm just kidding. So immediately after Katz and Berger, those two cases we went over, indicated the need for carefully drafted legislation authorizing electronic surveillance, Congress enacted the Omnibus Crime Control and Safe Streets Act of 1968. Title III of this act is officially called the Wiretap Act of 1968, and this was devoted to electronic surveillance. And this act has also been amended several times, included changes authorized through the USA Patriot Act, which we'll get to in a few minutes. So, the Wiretap Act of 1968, also known as Title III of the Omnibus Crime Control and Safe Streets Act of 1968, and recast in the Electronic Communications Privacy Act of 1986, is going to be referred to basically as just the Wiretap Act as I continue to discuss it, because it makes it a lot simpler for clarity. So this act makes it a federal felony to willfully intercept any wire, oral, or electronic communication by electronic or mechanical devices, unless an electronic surveillance warrant has been obtained. And this applies to real-time interceptions, retrieving stored data. It applies to real-time interceptions, but retrieving stored data falls under the Stored Communications Act. Now, the Wiretap Act detailed many requirements that have to be followed in order to obtain that electronic surveillance warrant. And although this statute only applies to federal agents, it's much broader, and it has much broader implications, because many states have either authorized their officers to proceed under identical laws or used it as a basis for state statutes. So if you look on page 425, you'll see some of those things that must be listed in order to actually apply for a surveillance warrant under this particular act. So, but what is not covered then? Well, what's not covered would be consensual taps or PIN registers. Remember, we talked about that, or trap and trace, or calls where there's no expectation of privacy, like from an inmate in prison. And the majority, about 85% of the warrants that have been issued, again, are for drug cases. And about 98% were to tap cell phones. So this Wiretap Act, as we know, it's a felony to place an illegal tap. And this covers writing and sound and image and data. And illegally gathered evidence is not going to be admissible. Now, later on, the Patriot Act came into play. So the USA Patriot Act added several categories of crimes to this list, but the majority of them were in the bill when it was passed in 1968. Now recent legislation added investigations of theft of medical products and construction or use of international border tunnels for smuggling drugs or illegally transporting people into the United States. But when you talk about what the warrants were issued for, you can look on page 424 and you can see where it says federal judges can issue a warrant to intercept electronic communication based on probable cause that any federal felony is being committed, and warrants for oral and wire communication can be issued by federal judges for the investigation of crimes specified in the Wiretap Act. And I'm not going to go through all of them because there's a lot of them listed in there, so you can take the time to do that. And then, as I pointed out, the Patriot Act extended coverage to more types of communication, like email and voicemail, and it also loosened some standards. So how do we apply for a TAP as it relates to electronic surveillance and the Wiretap Act of 1968? Well, we're going to kind of go over that. So to apply for a TAP, it must be delivered to a federal judge, and it's only going to cover certain crimes, and it covers most felonies. We know that. And we know the Patriot Act expanded that coverage now, specifically to include things like terrorism. And in the application, we have to identify certain things. So more facts must be included into an application for a Wiretap Act warrant than are usually needed to establish probable cause for let's say, a regular normal search warrant, if you will. And the code is very specific about what has to be included. And if you look on page 425, about a quarter of the way down, you can see the information that needs to be included. And I'll touch on just a few things. So like the identity of the investigative or law enforcement officer making the application and the officer authorizing the application. The senior officer who has approved the application. And complete facts about the case, probable cause, details of the crime, where, who, and how the intercept is to be carried out. So you can see how that is. A full and complete statement as to whether or not the investigative procedures have been tried and failed, or why they reasonably appear to be unlikely to succeed. So you have to even put in there, hey, you know what? I used these other things and they didn't work, or if I were to use them, they wouldn't work because of this. So this is kind of like alternatives to the wiretap were all exhausted, if that makes any sense. So you're going a little bit, you don't have to do that in other warrants. And then a statement of the time period on how long it's going to last. And at the end of it all, you're going to have to record any of the previous taps and their results. So there's a lot more facts and information. And in this, you're also going to have a full and complete statement of the facts concerning all previous applications known to the individuals authorizing and making the application made to any judge, authorizing for any intercept or approval for any wiretap, any oral or electronic communication. So just a lot of information that we have to do. And yes, the wiretaps, they can be renewed. And you can also get what is called an emergency tap. So if there is reason to believe that there's an emergency, you can go ahead and get that wiretap obtained quite a bit more quickly, if you will, than you would have before. So a wiretap warrant to monitor oral communication can be issued without listing the location where the wiretap will operate or the phone number to be monitored if the application gives a full and complete statement as to why such specification is not practical and identifies the person committing the offense and whose communications are to be intercepted. And another step that has to be completed when seeking a wiretap warrant is that the application must be reviewed before it is submitted to the judge. And federal law enforcement agents must have their warrant application screened by a senior member of the Attorney General's staff. So again, a lot of different critical issues as it relates to this. And then the communication obtained under the electronic surveillance warrant must be tape recorded and otherwise retained in a manner that prevents later editing or alteration. And these recordings have to also be made available to the judge when the surveillance has been completed. And they also have to be kept for 10 years and may not be destroyed without an order from a judge. And then the other kind of weird thing is that the persons whose conversations were intercepted must be served with a limited inventory, is kind of what they call it, within 90 days after their surveillance has ended. So the target of the tap has to be notified within 90 days of the end of the tap, and they have to be told first the fact of the entry of an order of application, the date of the entry and the period authorized, approved, or disapproved, etc. And the fact that during the period, wire, oral, or electronic communications were or were not intercepted. Now, the judge has the discretion to permit the persons whose communications were seized to see the application for the warrant and even to hear the taped interceptions. If the prosecution plans to use the evidence obtained during the surveillance in court, all parties must have access to the application and warrant at least 10 days before the testimony is introduced. So again, there are strict exclusionary rules that apply, meaning that if evidence is obtained illegally, it won't be able to be used in court, and we know what the exclusionary rule means. So in this case, Dahlia versus United States, police, in order to place a tap, had covertly entered a residence. And the Supreme Court here ruled that, you know what? The police have the authority to enter homes secretly to place wiretaps. Otherwise, how would they get them in there? And that's why when I go back to the information that was on page 425 that says that the warrant has to be extra detailed, and part of it has to be a information about how the tap is going to be put in and where it's going to be put in and what it's going to actually tap. Because otherwise, if people are home, you can't walk in and put the wiretap in there. So that's why the judges, they want that detailed information. So again, the information in this case was in fact deemed appropriate. So a little more. So the Supreme Court decided several cases regarding wiretaps. And probably the most important local, or the most important one to local law enforcement, is the one I just went over, that Dahlia case. And the issue was whether agents executing an electronic surveillance warrant could sneak into somebody's house and install the listening devices. And at that time, Congress had not addressed that particular issue. So the court found that the right to enter was kind of a fundamental part of the right to use the electronic devices. Otherwise, how would you get them in there? And they even went as far as saying, you know what, re-entry into the location to service the equipment or retrieve it at the end of the surveillance was also included. And there was no need actually for a separate warrant. So neither was it necessary to ask authorization for covert entries when the original surveillance was obtained. Although remember, they have to have a very detailed list of information in that particular warrant in order to make it admissible. And here's the U.S. versus U.S. District Court, Keith. Now here, 3 suspects were charged with destroying government property. And the police had had placed taps without warrants, claiming an exception under the OCC and SS Act of 1968, and I'll explain what that is in a second, as it was a plot to overthrow the government. And here the Supreme Court disagreed and ruled 8-0, requiring in domestic cases that the Fourth Amendment be applied. So again, kind of another interesting case. So a little more on the USA Patriot Act very quickly. The Department of Homeland Security, on October 8, 2001, President George W. Bush signed Executive Order 13228 establishing the Department of Homeland Security. And here's their mission. And one of their mission factors is to prevent terrorism and enhance security and secure and manage borders and safeguard cyberspace and strengthen national preparedness. And on October 26, 2001, President George W. Bush signed into law the Uniting and Strengthening America by Providing Appropriate Tools to Intercept and Obstruct Terrorism Act. Wow, the USA Patriot Act, that's a mouthful. And as we heard of, we're not going to get super detailed, this gave law enforcement the ability to search and detain and also to eavesdrop in pursuit of terrorists. Now keep in mind, when the USA Patriot Act expired in June of 2015, it was replaced by the USA Freedom Act, which was primarily the same thing with just a couple of changes. So in the case at the beginning, at what point does the government have the right to suspend constitutional rights? And in this Keith case, that case we just saw a second ago, that case law, it involved plans to dynamite offices at the CIA. And recently in Boston, after the marathon bombing, some called for the suspect to be treated as a terrorist. So what line can we draw and what criteria can we use as it relates to listening and obtaining of electronic information, etc.? So now we're going to talk a little bit about stored communication, and we don't have too much more to go. So hang in there. You're doing pretty good. In 1986, Congress passed the Electronic Communications Privacy Act, which extended the protections of the Wiretap Act to the transmission of data between computers. And the ECPA, that long name that I just said, that Electronic Communications Privacy Act, contains the Stored Communications Act. And the SCA allows law enforcement to obtain information using subpoenas and search warrants, depending upon circumstances. Now, if you look on page 429, you can see a really nice chart that lists comparisons of methods for obtaining documents. And on the left is the procedure, like search warrant. The next is the level of proof, like probable cause. The next is who must approve it, well, a trial court judge. And next is the method, police enter the premise, etc., etc. So it talks about all the different things. So take a look at that comparison method for obtaining documents. It's a really good way to, again, get some context to what we're talking about. So email and text messages are considered electronic communication at the time they are sent, and a warrant based on the Wiretap Act or the Foreign Intelligence Surveillance Act is needed to intercept them. And that's what they call FISA or FISA, however you want to say it. Now, officers need a search warrant to retrieve voicemail from a machine that a person has at his home, and access to voicemail, email, text messages, or other data that are stored by the communications company or internet provider is controlled by the SCA. Okay, so are you with me so far? So, as a review, 1986, Congress passed the Electronic Communications Privacy Act. And this allowed police to access stored information by either subpoena or search warrant. And this is necessary if accessing immediately from home. They generally need a warrant. And if stored, typically they only need a subpoena. So what about the Foreign Intelligence Surveillance Acts of 1978, and that's that FISA that I told you about? Well, although the Wiretap Act has an emergency provision that can be used in cases involving national security, the Supreme Court has narrowly interpreted it. And neither the President nor the Attorney General nor anyone else can authorize wiretaps on U.S. citizens, domestic dissidents, without judicial review. And that was that United States versus United States District Court Keith case. And in response to Keith, Congress passed the Foreign Intelligence Surveillance Act of 1978, that FISA, in order to provide a secure framework by which the executive branch may conduct legitimate electronic surveillance for foreign intelligence purposes within the context of the nation's commitment to privacy and individual rights. And it is the exclusive means by which electronic surveillance and the interception of domestic wire, oral, or electronic communications for foreign intelligence, unless Congress specifically designates other statutory methods. Now FISA or FISA has been amended to include provisions for physical searches as well inside the United States, and surveillance and searches outside the United States. So again, overall, it allows TAPS to combat foreign powers. And again, the U.S. Patriot Act expanded this act a little bit further. And it's overseen by an 11-judge panel appointed by the Supreme Court. And this electronic surveillance warrant, it has to be first reviewed by the Attorney General, and it covers more targets now and for longer times, and it can actually place TAPS for up to 1 year, and sometimes without warrants. So I know it's confusing, but just kind of, let's just take it like one piece at a time, and it makes it a little bit easier. So in order to apply for this FISA warrant, there are a lot of things that have to be put in there, kind of like the last one we talked about. The identity of the federal officer filing the application, the identity of the target, the facts that would sustain belief of danger, the target being a foreign power, the minimization procedure, what information are you looking for, the certification by a presidential assistant, how surveillance is going to be done in previous applications and surveillance, and how long will the current tap go or run. So a lot of info, you guys. So finally, we'll finish up with just a couple of quick things. So the physical search part that I spoke of, remember this FISA allowed physical searches after 1994. And the must show falls under a foreign power or agent, and it's very broadly defined. And other devices for a trap and trace, let's say, they do need less than probable cause. And then finally we'll talk about business records and national security letters. Well, under this act, you can file a request with the FISA judges to get records, and no probable cause is required here, but you still must show the records relate to or are in custody or control of a foreign power, and that's how you're going to be able to get those. And then the national security letters, they don't require judicial review. They simply require a request from law enforcement to a third party holding a suspect's records, and requires the third party to keep the request of the records secret, but must involve a foreign counterintelligence case. So that's just briefly kind of an overview. Now, again, this chapter would be great, and you would truly benefit by going back and looking at the examples, because this was a tough chapter to really go through. And I hope I was able to break it down to a level that everybody could understand some of the larger topics that we went over. So if you have any other questions, please post them on the discussion board. If you don't want to do that, you can send me an email. And don't forget about the resources, the student resources in your textbook. So with that being said, that'll conclude our lecture on Chapter 14. Until next time.